law over the past year. These include the International Criminal Court's Al-Mahdi case and conviction, the closing and legacy of the two ad hoc tribunals, the Rwanda and the Yugoslavia tribunals, and the ongoing situation in Syria. So first, the International Criminal Court Al-Mahdi case, which I'm sure many of you are familiar with, which we have also discussed in previous panels at this year's conference. Ahmad al-Faqi al-Mahdi was a member of the radical Islamic group Ansar ad-Din, which is essentially a Malian armed jihadist group linked to al-Qaeda in the Islamic Maghreb. Al-Mahdi served as head of the Islamic police in Timbuktu, was one of 4 commanders of Ansar ad-Din during its brutal occupation of Timbuktu in 2012. During this time, he worked closely with leaders of all armed groups in the area, and according to the allegations that were asserted against him, he played an active role in the occupation of Timbuktu. The Malian government itself referred the situation in Mali to the ICC in 2012, and the Office of the Prosecutor then opened an official investigation in January of 2013. In February 2013, the Malian government and the ICC signed a cooperation agreement in accordance with Section 9 of the Rome Statute. On September 18, 2015, the ICC pretrial Chamber 1 issued an arrest warrant against al-Mahdi, and at this particular point in time, he was detained in a prison in Niger. Just 8 days later, on September 26, 2015, he was transferred to ICC authorities by the government of Niger. On March 24, 2016, charges against al-Mahdi, constituting of war crimes constituted by attacks against religious and cultural sites, were confirmed by pretrial Chamber 1, and al-Mahdi was indicted by the ICC on several charges of war crimes. He indicated that he would plead guilty as early as March 1st of 2016. His trial ultimately opened about a year ago on August 22nd, 2016, and concluded within a single week. He was sentenced to 9 years of imprisonment on September 27th, 2016. And in the most recent development, just about a week ago, on August 17th of this year, Trial Chamber 8 of the International Criminal Court issued a reparations order in the al-Mahdi case, concluding that he's liable for 2.7 million euros in expenses for individual and collective reparations for the community in Timbuktu for intentionally directing attacks against religious and historic buildings in that city. As Judge Van den Wingard reminded us last night, it is unlikely that he will actually be able to pay, and it is most likely that the trust fund will actually pay the reparations. But this ruling is really symbolic because it carries a message that crimes committed against cultural sites, religious sites are of particular value to the ICC, and that these crimes will be taken seriously by the ICC in the future. Now, is the al-Mahdi case a big victory for the ICC, or does it somehow stretch the limits of international criminal justice, as some have pointed out, to its breaking point? So first, some commentators have applauded this case and called it a big victory for the International Criminal Court. According to this argument first, al-Mahdi's trial was short and efficient, which is really important for a court that has been hobbled by inexcusably long proceedings. The ICC, as all of you know, has a small budget, and completing an efficient trial without expending many resources represents an important legal accomplishment for the tribunal and will arguably free up the court for future important investigations and cases. Al-Mahdi is also the first ever defendant in the ICC to plead guilty. From the start of the case, he had promised to cooperate with the ICC in exchange perhaps for a lenient sentence, but prosecuting al-Mahdi while knowing in advance that the defendant would plead guilty and cooperate with prosecutors and also perhaps provide information about future cases would appear to have been a particularly efficient use of the ICC's limited resources. And as the dates that I've highlighted to you indicate, this case really unfolded very quickly from the opening of the investigation into the situation in Mali all the way to the conviction and sentencing of al-Mahdi himself. Second, the ICC has been perceived as a largely inefficient institution by some, as cases against other alleged criminals have languished. So, for example, the Sudanese president al-Bashir has been free since becoming the first person charged by the ICC for genocide. Joseph Kony, the notorious leader of the Lord's Resistance Army, continues to wreak havoc in Central Africa 10 years after being indicted. And the trials of the Kenyan President Kenyatta and Deputy President Ruto collapsed as a result of a lethal combination of questionable case construction by the prosecutors and Kenyan political interference. Securing a conviction against an Islamic terrorist such as al-Mahdi, according to some, will send the right message that the ICC is efficient and capable of arresting individuals and successfully completing trials within a reasonable period of time. Third, al-Mahdi's surrender to the ICC was accomplished through the cooperation of both Niger and Mali, two African states. This cooperation may help the ICC to counter criticism of bias against the African continent and the perception that African states are somehow against the institution. Fourth, al-Mahdi's evidence and testimony could be of use during future prosecutions, and as I already mentioned, he has proven more than willing to cooperate with the ICC investigators and prosecutors. He may have been targeted by the ICC because of this promise, as the ICC may have believed that al-Mahdi's cooperation and eventual testimony would potentially help in bringing other perpetrators in Mali to account. As one commentator has observed, quote, if al-Mahdi provides solid testimony and evidence of other crimes, he could emerge as an extremely useful resource not only for the ICC, but for accountability in Mali more generally, end of quote. This possibility may help alleviate the skeptics' concern that the ICC should not be focusing on the destruction of property, but should instead focus on violence against populations and individuals. Fifth, al-Mahdi's conviction may bolster the court's image as a relevant institution seen as prosecuting crimes that shock the conscience of mankind, such as the destruction of UNESCO sites. While many have pointed out the limitations of the al-Mahdi precedent in terms of deterring future war criminals tempted to destroy other future cultural sites, the al-Mahdi case does demonstrate that the international community cares about the protection of buildings and monuments and is willing to expend focus and energy on this issue. Sixth and finally, the al-Mahdi case is a first of many kinds. This case marks the first time that the destruction of cultural sites has been prosecuted as a war crime at the ICC. It is also the first time that an Islamic radical has been prosecuted at the ICC, and it is the first time that an ICC defendant has pled guilty. Despite all of these good reasons why the al-Mahdi case may have been an excellent use of the court's time, some have criticized the case and have pointed out that this is not such a welcome development in international criminal law. Some scholars have criticized the al-Mahdi case as stretching the limits of the ICC to a breaking point because the case fails to respect two core principles of the ICC, gravity and complementarity. So first, gravity. The ICC was established to exercise its jurisdiction over persons for the most serious crimes of international concern. Article 17(1)d of the Rome Statute provides that a case is inadmissible before the ICC if the case is not of sufficient gravity to justify further action by the court. The prosecutor has stated, in the context of the al-Mahdi case, that the attacks against religious buildings are so grave that they warrant action by the international community. One has to wonder, however, whether the destruction of buildings should qualify as one of the most serious crimes of international concern. In another recent case, the so-called flotilla incident, where Israeli special forces killed 10 activists on board a vessel that had been about to breach the Israeli naval blockade of Gaza, the International Criminal Court Office of the Prosecutor has defined the principle of gravity as whether the individuals or group of persons that are likely to be the object of an investigation include those who may bear the greatest responsibility for the alleged crimes committed, and whether the gravity of the crimes committed within the incidents which are likely to be the focus of an investigation. Subsequently, the Office of the Prosecutor defined the elements that are to be taken into account when assessing the gravity of the crimes, such as, for example, the scale, nature, manner of commission of the crimes, and their impact. So with this precedent in mind, it is important to address two questions: whether al-Mahdi himself bears the greatest responsibility for the alleged crimes, and whether the crimes themselves are of sufficient gravity. First, it is somewhat unclear whether al-Mahdi is indeed the most responsible for the crimes. While it is likely that he had been involved in the destruction of the religious buildings, it is equally likely that other members of the Islamic groups were equally involved in the planning and commission of those crimes. It has been suggested that al-Mahdi was put on trial because all of the other leaders of the various extremist militia groups that operated in the regions have been killed or otherwise escaped. In other words, he was the only one available. This suggestion would indicate that al-Mahdi was selected for prosecution for pragmatic reasons, which had little to do with the gravity principle itself. Second, it is uncertain whether the war crime of destruction of cultural property is grave enough to warrant prosecution in the ICC. Despite the Rome Statute's prohibition against the destruction of religious buildings, one must assume that the drafters imagined that these crimes would only be prosecuted once committed in combination with other crimes that qualify as a war crime and that are committed against persons, not buildings. So, for example, in the Curran and Taganda trial, the defendant is facing 12 war crimes charges and 5 charges of crimes against humanity, in addition to the destruction of cultural and religious property. And so the Taganda case seems to pass the gravity threshold more easily, perhaps, than the al-Mahdi case. Second, complementarity. It is questionable whether the al-Mahdi prosecution satisfies the principle of complementarity. According to Article 17(1)(a) of the Rome Statute of the ICC, a case is inadmissible when it is being investigated or prosecuted by a state which has jurisdiction over it, unless the state is genuinely unwilling or unable to carry out the investigation or prosecution. And we had a chance to talk about complementarity just a few minutes ago at the end of Jennifer Chan's presentation, and to wonder about what complementarity truly means. Here, though, al-Mahdi had already been indicted on terrorism charges in Niger before the ICC issued its arrest warrant, and he was actually detained by Niger authorities at the time that he was transferred to the ICC. When Niger was informed that the ICC wanted to prosecute al-Mahdi, Niger authorities transferred the case and relinquished jurisdiction over the al-Mahdi prosecution, and Niger never officially stated that it was unwilling or unable to prosecute al-Mahdi, and the ICC authorities never really bothered with the complementarity issues. Thus, it seems that the ICC decision to prosecute al-Mahdi may be contrary to the complementarity principle, and in light of the fact that the case might not pass the gravity threshold, one has to wonder whether the al-Mahdi prosecution should have remained in the hands of Niger authorities. To conclude, while this case may be applauded as a precedent-setting victory for the ICC as an institution and for international criminal law in general, the case can also be criticized as an improper use of the court and of its limited resources to prosecute a lesser-known defendant for relatively insignificant crimes. The case remains relevant, however, for another reason, and demonstrates that the ICC may function properly if cases are carefully selected and referring states actively cooperate in the defendant's arrest and prosecution. It may be better, according to some, for the ICC to pursue lesser-known defendants if the Office of the Prosecutor determines that a conviction can likely be secured with limited resources than to issue arrest warrants against defendants who are unlikely to find their way to The Hague. According to some, limited justice may be better than no justice at all. My second theme for today, the closing and legacy of ad hoc international criminal tribunals, and here I will focus on the Rwanda and the Yugoslavia tribunals. As all of you know, the Rwanda tribunal officially closed, having completed all of its trial and appellate level work at the end of 2015. The ad hoc criminal tribunal for the former Yugoslavia is also coming to a close. The tribunal is currently finishing its last trial in the Mladic case, with a judgment expected in November of this year. And in the last appellate case, Perlic and others, the appellate judgment is expected also in November of this year. Remaining proceedings in the cases of Karadzic, Šešelj, and Stanisic and Simatovic are under the jurisdiction of the so-called Mechanism for International Criminal Tribunals, and the mechanism, as most of you know, has been mandated to essentially perform a number of essential functions that had been previously carried out by the Yugoslavia and the Rwanda tribunals. Now, with the closing of these ad hoc tribunals, an important chapter in international criminal law has come to an end. The Yugoslavia and the Rwanda tribunals played crucial roles in the development of international criminal law 4 decades post-Nuremberg. They reignited the development of this field of law, and their case law contributed towards the fine-tuning of complex legal doctrines such as genocide, superior in command responsibility, the definition of international armed conflict, the prosecution of crimes of sexual violence, and many others. So what are the legacies of the Yugoslavia and Rwanda tribunals? In the general context of international criminal tribunals, scholars have defined legacy to mean a lasting impact, most notably on bolstering the rule of law in a particular society by conducting effective trials while also strengthening domestic capacity to do so. Legacy in this context implies the extent to which a particular court has had a significant effect by modeling best practices in handling the individual cases and compiling a historical record of the conflict. Legacy also means laying the groundwork for future efforts to prevent a recurrence of crimes by offering precedents for legal reform, building faith in judicial processes, and promoting greater civic engagement on issues of accountability and justice. Here today, though, I would like to focus on a particular legacy of the Yugoslavia and Rwanda tribunals in the field of international humanitarian law and international criminal law, and to ask what is the significant impact and legacy of the tribunals through this particular lens. It is my hope, and other scholars and experts hope, that the legacy of the ad hoc tribunals in the fields of international criminal law and international humanitarian law will be of particular assistance to those who work with the International Criminal Court, as much of the ad hoc tribunal's case law has served and will serve as important precedent for the ICC, and as the ICC will most likely continue to enhance the same international humanitarian law and international criminal law principles and doctrines which the ad hoc tribunals have already developed. So first, the ad hoc tribunals have contributed to the development of international criminal law by successfully charging and convicting defendants of genocidal offenses. The Rwanda tribunal in the Akayesu case became the first international tribunal to enter a judgment for genocide, as well as the first to interpret the definition of genocide set forth in the 1948 Geneva Conventions. In the Kambanda case, also before the Rwanda tribunal, the defendant pled guilty to genocide, marking the first time in the history of international criminal law that an accused person admitted responsibility to and for genocide and conspiracy to commit genocide. And by accepting this guilty plea in the Kambanda case, the Rwanda tribunal became the first international tribunal since Nuremberg to issue a judgment against a former head of state. And in another case, the Rwanda tribunal convicted members of the Rwandan media by holding them responsible for broadcasts intended to inflame the public to commit acts of genocide, thereby also contributing to existing case law on genocidal offenses. The Yugoslavia tribunal was the first international criminal tribunal to enter a genocide conviction in Europe. In April of 2004, in the case of Krstić, the appeals chamber determined that genocide was committed in Srebrenica in 1995 through the execution of more than 7,000 Bosnian Muslim men and boys following the takeover of the town by Bosnian Serb forces. Several other completed Yugoslavia tribunal cases relating to the events at Srebrenica have ensured that the genocide has been well documented, and in the words of the ICT President Theodore Meron, consigned to infamy. In sum, the ad hoc tribunals have significantly contributed toward the prosecution of the crime of genocide and towards the notion that genocide is a crime against all that will never again be tolerated by the international community. Second, the ad hoc tribunals have contributed to the development of international criminal law and international humanitarian law by developing case law on crimes of sexual violence and by focusing on specific gender issues. In the Akayesu case, the Rwanda tribunal for the first time defined the crime of rape in international criminal law and recognized rape as a means of perpetrating genocide. The Rwanda tribunal also created a special unit for gender issues and assistance to victims of genocide, choosing to focus on gender issues and to provide support and care to the victims of genocide. In this manner, the tribunals have, in addition to developing case law on crimes of sexual violence, created a participatory legacy, the idea that victims of serious crimes have a voice within international criminal prosecutions of such crimes. This idea, for better or for worse, is squarely present within the Rome Statute of the International Criminal Court. The Yugoslavia Tribunal has also played a historic role in the prosecution of wartime sexual violence in the former Yugoslavia and has paved the way for a more robust adjudication of such crimes worldwide. From the first days of the tribunal's mandate, investigations were conducted into reports of systematic detention and rape of women, men, and children. More than a third of those convicted by the Yugoslavia Tribunal have been found guilty of crimes involving sexual violence. Such convictions are one of the tribunal's pioneering achievements. They have ensured that treaties and conventions which have existed on paper throughout the 20th century have finally been put in practice and violations punished. Third, both of the ad hoc tribunals have contributed towards the development of the doctrine of superior responsibility by holding that superior responsibility applies to civilians in leadership positions, and that this concept is not confined to purely military leaders. This contribution by the ad hoc tribunals is particularly relevant in light of modern-day warfare, where conflicts are often fought outside of well-defined militaries and where orders and policies are often crafted by non-military leaders. Fourth, the ad hoc tribunals have established a legacy of cooperation and impact on domestic jurisdictions between international tribunals and national authorities. Multiple countries have signed agreements on the enforcement of Rwanda tribunals' sentences, and these agreements illustrate the important roles that national authorities play in ensuring that those convicted of serious violations of international law will actually serve their sentences in compliance with international detention standards. In addition, the Rwanda Tribunal upheld the first referral of an international criminal indictment to Rwandan national authorities for trial, and a total of 8 ICTR cases have been referred to Rwanda, with 2 additional cases that have been referred to France for trial for national authorities, with monitoring of all these referred cases presently being conducted by the mechanism. Throughout its existence, the Yugoslavia Tribunal's Office of the Prosecutor has worked closely with new states and territories that emerged from the former Yugoslavia on their domestic prosecutions. In the aftermath of the war in Bosnia and Herzegovina, returning displaced persons and refugees voiced fears about arbitrary arrest on suspicion of war crimes. To protect against this, the Office of the Prosecutor agreed to operate a rules of the road scheme under which local prosecutors were obliged to submit case files to The Hague for review and for ultimate approval at The Hague for any subsequent national prosecution. To ensure that as many persons as possible suspected of war crimes are brought to justice, the Office of the Prosecutor at the Yugoslavia Tribunal has provided assistance to national bodies in the region by passing on evidence that may have been of use in local investigations and by transferring whole cases for prosecutions locally. A dedicated transition team within the Office of the Prosecutor was tasked with handing over to national courts cases involving intermediate and lower ranking accused. Such cases have included case files of suspects investigated by the Office of the Prosecutor, where no indictments were ever issued. These cases were then referred to national authorities in Serbia, Croatia, and Bosnia. Now, we recently heard, I think it was just yesterday, that Kevin Hughes, who is here on behalf of the mechanism, expressed skepticism about how those cases have actually proceeded within the national authorities, and that many of the cases were not actually prosecuted, that some cases were stalled on purely technical grounds. But nonetheless, I think it is true that the Office of the Prosecutor has at least attempted to work with national authorities, to transfer cases to national authorities, and to rebuild capacity in this way within those national jurisdictions. The Office of the Prosecutor has also promoted regional cooperation among national prosecutors. The ICTY Prosecutor's Office has strongly supported efforts to enhance cooperation in criminal matters between states of the former Yugoslavia, as this is seen as an essential step towards rebuilding trust and justice in the region. Fifth, the ad hoc tribunals have created a significant legacy in the operational sense by establishing specific case management strategies for the prosecution of complex international crimes, and by establishing particular evidentiary procedures resulting in the long-term preservation of evidence, which will enable national jurisdictions to prosecute additional cases in the future. So, for example, the Rwanda Tribunal held special deposition proceedings in the case of Felician Kabuga to preserve evidence for use at trial once he's arrested. And similar proceedings were later held in 2 other cases involving 2 other fugitives. By holding this type of proceedings, the Rwanda Tribunal attempted to assure that the passage of time does not jeopardize the international community's ability to bring these suspects to trial once they're finally apprehended. The Yugoslavia Tribunal has established specific evidentiary standards regarding victims of crimes of sexual violence by allowing them to testify anonymously. Witnesses have been able to testify under a pseudonym with face and voice distortion in video feeds or in closed session. Through the development of its rules of procedure, the Yugoslavia Tribunal has also sought to protect the victims of sexual violence from abusive lines of questioning during testimony. The ad hoc tribunals, the Yugoslavia and the Rwanda tribunals, have thus left behind an operational legacy which will undoubtedly serve as a model for future international criminal prosecutions. And finally, my third theme for today, the ongoing situation in Syria. And here I would like to talk a little bit about the recent United States use of force against the Assad leadership in Syria, as well as about possible models of accountability for crimes committed in Syria. Back in 2013, President Obama drew a red line and threatened that the United States would use force against the Syrian regime in the wake of the latter's use of chemical weapons against Syrian civilians. President Obama ultimately decided against using force in Syria, but President Trump reversed this decision and launched several airstrikes against the Syrian President Assad's forces in 2017. President Trump offered the following justification for the United States airstrikes against Syria. First, that it was in the vital national security interest of the United States to prevent and deter the spread and use of chemical weapons. Second, that Syria used banned chemical weapons, violated its obligations under the Chemical Weapons Convention, and ignored the urging of the United Nations Security Council. And third, that the refugee crises continued to deepen and the region continued to destabilize, threatening the United States and its allies. Notwithstanding President Trump's justification for the use of force in Syria, most international law experts would agree that the United States' use of force in Syria this year has been illegal. As we all know, international law allows the use of force in two limited situations, pursuant to Security Council authorization and or in self-defense. In this situation, no particular Security Council resolution has authorized the use of force in Syria, and it is very difficult for the United States, located thousands of miles away, to claim that it has somehow been threatened by the Assad regime and that it must act in self-defense. The United States use of force in Syria is significant, however, for another reason. This intervention can be analyzed from a different standpoint, that it may be acceptable, while not legal, for states to act outside the framework of the United Nations Charter when deemed necessary or when pursuing some legitimate purpose. Many of you may remember that this was partially the argument used to justify the 1999 NATO airstrikes against the Federal Republic of Yugoslavia. In 2013, the United Kingdom Prime Minister's Office argued, in the wake of the ongoing crises in Syria, that a state could take exceptional measures in order to alleviate the scale of the overwhelming humanitarian catastrophe in Syria by deterring and disrupting the further use of chemical weapons by the Syrian regime. According to this rationale, this argument, such a legal basis is available under the doctrine of humanitarian intervention, provided that a set of conditions is met. These conditions include, first, that convincing evidence, generally accepted by the international community as a whole, of extreme humanitarian distress on a large scale requires immediate and urgent relief. Two, that it is objectively clear that there is no practicable alternative to the use of force if lives are to be saved. And three, that the force used is necessary and proportionate to the aim of relief of humanitarian need. In other words, the United States military action in Syria has resurrected debates regarding the humanitarian intervention exception to the general ban on the use of force in international law. As of today, most of us would agree that humanitarian intervention has not become a norm of positive law. And moreover, in the Syrian context, it appears that American airstrikes have not contributed toward a broader humanitarian mission and cannot be easily interpreted as constituting part of a larger humanitarian operation. It seems that the humanitarian intervention exception does not provide an easy legal basis for the American use of force in Syria. The Syrian situation, however, underscores and highlights the limitations of international law. Despite the general ban on the use of force that has existed in international law since the end of World War II, The United States military action in Syria does not constitute the first time that the prohibition on the use of force has been violated and not sanctioned by the international community. This, however, should not necessarily mean that the legitimacy of the UN Charter is automatically diminished. Instead, the U.S. military action in Syria highlights the limits of international law and is herein tied to international relations and geopolitics. The United Nations Security Council, the only international law body authorized to officially bless the use of force against a sovereign state, is often blocked and unable to take legal action, resulting at times in a unilateral use of force by countries like the United States in an illegal, yet perhaps according to some, legitimate manner. The obvious risk that such unilateral military action creates is, although the attack here in the Syrian context may be seen as morally or ethically legitimate, it nonetheless results in acts committed outside the purview of international law. This dangerously opens the door to using force under possible false pretenses in the future. Of course, the same false pretenses could be pursued within the boundaries of the existing legal framework, but at least the law acts as a barrier in limiting the recourse to force in such situations. In sum, the United States intervention in Syria has sparked new debates regarding the limits of international law and regarding the legitimacy of the humanitarian intervention exception. Finally, the Syrian situation has resulted in an ongoing debate within our professional circles regarding the best accountability mechanism to address violations of international criminal law and international humanitarian law committed in Syria. While all agree that those responsible for such violations should face justice, many disagree as to which justice, international, hybrid, or domestic. The ICC, because of its jurisdictional limitations, is of limited use in Syria, but a new Syria tribunal could be established either pursuant to a true international model, similar to the Yugoslavia and Rwanda tribunals, or pursuant to a hybrid model, similar to the Special Court for Sierra Leone or the Lebanese tribunal. Or accountability could be imposed through domestic justice, assuming that the Syrian leadership is reformed and is able and willing to meet the demands of accountability. To conclude, Syria may sadly preoccupy our legal minds for years to come. Now, other than the Al-Mahdi conviction in the International Criminal Court, the international law themes of the past year, which I have addressed here today, have not been happy. This conclusion, however, does not diminish the role of international law, and in particular of international lawyers in matters of international criminal justice. I encourage all of us to continue our hard work in the field of international humanitarian law and to continue to contribute towards the development of this area of the law. And as Judge Van den Wingard stated last night, quoting Ben Terence, do not give up. Thank you.